Dr. Ambedkar is always, shown as if he was a great enemy of Hindus, great enemy of Sanatana Dharma, and therefore he is always projected to be an antithesis to Hindutva and Bharatiya thought. Now, why am I citing Ambedkar in the initial phase is because Ambedkar all the time was the conscience keeper in the Constituent Assembly and beyond. Now, we may have 100 disagreements on some of the aspects that Dr. Ambedkar espoused then, but today all his prophetic words have come true. Law and religion are now different. Both emanate from the words of Allah. So if Allah has commanded a particular thing to be done in a particular manner, that applies to law also. There is no difference between Islamic personal law and Islam per se, Islam as a religion. 1946 elections. 1946 elections, 90% of the Muslims all over India voted for Muslim League candidates, including those in Bangalore. There were Muslim electorates, so all of them voted. Daniel Latifi was a communist. He supported Muslim League by saying Hindus are exploiters. The Lalas and Baniyas of Lahore have exploited the Muslim masses. So Muslim League is nothing but communist party in the renewed phase. So therefore we should support the Muslim League. And partition is nothing but a communist revival. The Muslim fundamentalists always support these draconian laws. That is because Islam can be revived and sanitized only by women. And if women rise up to the occasion, then the real revolution starts. I would like to tell you a very interesting chapter from the era of emergency and then move on immediately to UCC. Niren Day was the Attorney General of India. You have various structures of legal officers in the court. In High Court, we have Advocate General, who is the head of the state government's legal department. Similarly, you have Attorney General in the Supreme Court representing, he is the highest legal officer in the Supreme Court in entire India. Now, Niren Day was asked by the Constitution bench that was hearing the famous ADM Jabalpur matter. We all know what is ADM. I would like to tell you, I thought it's a legal audience and I'm presuming that we all know. ADM Jabalpur is a very interesting case. In Jabalpur, a set of youngsters were arrested. Most of them were less than 18 years, but they were shown as above 18 years because you can't arrest a minor. So they were all arrested, taken to prison without showing any records. They were imprisoned for several days. And finally, the matter came up before the Jabalpur High Court. The defense taken by the central government then was that all fundamental rights get suspended during internal emergency, even the right to life. So therefore, the writ of habeas corpus to get the person's body is also suspended. So the same bench which was hearing this matter in the Supreme Court, ultimately Supreme Court buckled down and finally held that there are no fundamental rights available during emergency. In this very case, how it all happened is very interesting. Niren Day was arguing and an inspector was standing next to him. The very inspector who had arrested, I think his name was Shivnarayan Singh. He was standing next to the Attorney General. The Chief Justice asked a question. I think A.N. Ray was the Chief Justice. A.N. Ray asked, he was the Chief Justice after superseding 4 seniors. Now all 4 or 5 people resigned in protest against A.N. Ray being made the Chief Justice. So he asked the question to Niren Day, what if the inspector standing next to you takes a service revolver and shoots at us? What happens? Because the fundamental rights are suspended, we have no right to life also. So Niren Day said, yes, it is very unfortunate, but it is true. I am helpless. You can be shot dead. Now just imagine the mindset of judges deciding the case. If they decide against him, against the government, they risk their lives. So this was the situation prevailing during emergency in 1975. Perhaps we are just about 48 years away from that draconian truth. So these are the very people who threatened the Supreme Court judges to shoot down from service revolvers of the inspectors are the ones who are now saying, crying from the rooftop saying Constitution is under threat, fundamental right is under, all this nonsense should be shown to them that these are the realities which, were the living realities of some of them at least assembled here. So now, another icon who is always brought in to fore in criticizing the nationalist ideas, Bharatiya ideas, is Ambedkar. Dr. Ambedkar is always, shown as if he was a great enemy of Hindus, great enemy of Sanatana Dharma, and therefore he is always projected to be an antithesis to Hindutva and Bharatiya thought. Now, why am I citing Ambedkar in the initial phase is because Ambedkar all the time was the conscience keeper in the Constituent Assembly and beyond. Now, we may have 100 disagreements on some of the aspects that Dr. Ambedkar espoused then, but today all his prophetic words have come true. One such thing is his treatise on the partition of the nation, wherein he said that unless there is a population transfer, both countries will not progress. Bharat will always be engrossed in communal strife. So therefore, the country should be divided on the communal lines entirely, on population transfer. This was one of the ideas that he espoused at that point in time. So he was speaking in the Constituent Assembly. Some of the Muslim members were heavily opposed to the idea of Uniform Civil Code. Dr. Ambedkar initially wanted the Uniform Civil Code to be one of the, in chapter 3, to make it one of the fundamental rights. But the opposition within Congress and predominantly in the Muslim sections, pushed this Uniform Civil Code to the directive principles of the state policy. Article 55 now is directory, not mandatory, is what is being argued. Now, what Dr. Ambedkar said to the Muslim members is, in the matters of succession, in fact, the Sharia law was not applicable to Northwestern Frontier Province itself. This is very interesting. We have all the fond memory of Khan Abdul Ghaffar Khan, 7 feet tall, really tall in every respect. Khan Abdul Ghaffar Khan was one of the champions of true secularism in the pre-independence era. Secularism has now lost its meaning. There is no point in deliberating the actual. But if you want to really deliberate on what actual secularism stands for, you must see the life and times of Khan Abdul Ghaffar Khan. And thanks to his struggle, he never allowed the Sharia law to be implemented in Northwestern Frontier Provinces till 1935. At that stage, Jinnah started blackmailing Congress by saying that he will side with Congress, he will delay the independence movement. So at that juncture in 1937, the Sharia Application Act was enacted by the British Parliament and then applied to those provinces. And in fact, if you see Mumbai province included North Karnataka. I am from Dharwad. North Karnataka was part of Bombay province. And Bombay province, in the matters of succession, if you see the case laws of those times, the decisions of the courts of those times, you see Hindu Succession Act being applied to Muslims. And Bombay, mind you, Bombay province was so big that it included about 30% of Karnataka, the Kalyana Karnataka as we call it, then the entire Gujarat and entire Maharashtra, except Nizam's provinces in Vidarbha region. Now, in Marathwada region, I'm sorry. So, that was the big expanse of the Bombay province then. And United Province, the entire UP today, Uttar Pradesh, had Hindu laws applied to all sections. And in North Malabar, people from Kerala will tell you that most of the Muslim converts in northern Kerala and some parts of Kodagu and Dakshina Kannada, undivided Dakshina Kannada in Karnataka, are mostly Nayars and Brahmins. They did follow the Aliya Santana law. The Aliya Santana law even today is followed to very small extent in some places, but entire Muslim population of North Malabar, not just North Malabar, entire Malabar followed the Aliya Santana law. Next slide, please. So therefore, Dr. Ambedkar said that how can the Uniform Civil Code be not applied? You yourself followed Uniform Civil Code at one juncture without being conscious of it. So Shah Bano is a very interesting case. I think some of us have heard, or most of us have heard, or almost all of us have heard, but the nitty-gritties are very interesting. I'll tell you how actually this case evolved. Now, Shah Bano's husband was Muhammad Ahmad Khan. He died in 2006 at the age of 93. Very great man, never allowed a single penny to be paid to his wife. Such a staunch lawyer. He was a senior advocate in Indore bar. Now, he had, at one point of time, I'm told, that he was the highest income tax payer in Indore. He had a wealth of 1 crore rupees at one point in time, which hard cash, not the immovable property, hard cash. Because he always accepted, like any crooked lawyer, he used to take fees only in cash. So very, very sought after man in Indore. So after his marriage with Shah Banu, after 14 years of his marriage, he married another woman. Today, I was seeing in the newspaper, maybe you can just Google and find out. Assam, former minister of Assam has been arrested along with his wife for torturing a maid servant. Age of the ex-minister is 84, wife's age 28, and maid servant's age 14. You can Google, you can find out. His name is, I think, Haji Rauf, a former member of Assam Gana Parishad. So illustrious was our Muhammad Ahmad Khan. Muhammad Ahmad Khan had a roaring practice in Indore, and he divorced his wife when she was 62 years old in 1978 and stopped payment to her. 200 rupees payment was, 200 rupees was paid, so that also was stopped. The ground taken was that after the iddat period, Muslim wife does not survive to be a wife. She no longer remains the wife. So if I divorce somebody, if a Muslim divorces somebody, after the iddat period is, if the woman is menstruating, then 1 month, then if she is beyond the menstrual cycle, 3 months. So after 3 months, you have no obligation to pay any compensation to a divorced wife. He took 2 grounds in the Madhya Pradesh High Court and in the trial court. First ground was that Muslims pay meher or dohar, and that dohar amount becomes a compensation amount at the time of divorce. So I have paid around 5,000 rupees at the time of meher. So 5,400 rupees during divorce. So I no longer owe any amount to her. One ground. Second ground is that no secular law is applicable to Muslims because I am governed by Sharia law, and Islam is absolutely clear that once you divorce a woman, after the iddat period, she doesn't remain your wife. So there is no obligation, legal obligation or moral obligation to pay any amount. I asked when this case law was being taught to us in law college, I asked a very progressive communist professor of ours, how do you explain this? He was also incidentally a Muslim. And he said, look, Hindus have no idea how Muslim marriages take place. It is simple contract. You see, contract. You leave a job, then what is the employer-employee relationship? Nothing. And what is the only thing you can ask for? Compensation. You can't say I have to reinstate. Nothing. Just paisa, khula. So I asked him, so Muslim women have no feeling, no right to life, no right to livelihood, etc. He said, no. You see, in Hindus it is a problem. Second marriage is a big problem. Muslims, people are waiting to get married. This was the answer given. Did he say it in frolicsome mood or he said it seriously? I don't know. But according to him, this was a non-issue. This was a total non-issue. He asked me, of all the crores of Muslim women, why only Shah Banu came to court? Because all Muslim women know Islam, that there is no contractual relationship. It is simple contract, like a rental agreement, like any other, it's as simple as that. So between a rental relationship, what is the emotional quotient? Nothing. So coming next to, just switch it on. So coming next to the aspect of maintenance, she filed a case under Criminal Procedure Code. You see, even today, an estranged wife, a deserted wife, neglected wife, or a divorcee who has not been paid the compensation amount at the time of divorce under 127 of the CRPC approaches the criminal court, family court, under section 125 of the CRPC. Now see this interesting aspect. Muhammad Ahmad Khan was a criminal lawyer, and I was thinking, when I studied this case in college, I was thinking that if Muhammad Ahmad Khan argued that section 125 of the criminal procedure code is not applicable to him, then the judge should have asked him, then Muslim criminal law should be applied to him. If civil code is not applicable to you, if you want to have your separate civil code, then better have criminal code also. I'll come to that interesting story, how criminal jurisprudence in Islam evolved and why Muslims want a secular criminal code but a communal civil code. So in November 78, Ahmad Khan gave triple talaq, proudly gave triple talaq to his wife, got rid of her, and he said, I don't owe any money. He paid this 5,400 rupees as meher amount. In fact, that meher amount was paid by her to him at the time of marriage. That is even more interesting. Dowry system still prevails in Islam in all the states, and meher amount, in fact, to be paid by husband to wife is always paid by wife to husband. That is a common practice. That much they are Hindu, in terms of dowry. So that amount was repaid by him, but the court held, interestingly, trial court held that he has to pay a compensation of 25 rupees per month. Trial court held a big amount. Then it was increased to 179.2 in the High Court. The matter went to Supreme Court. When this matter came to Supreme Court in 1981, two-judge bench of the Supreme Court, one of them was a Muslim judge, he disagreed with his Hindu brother judge, said, no, see, in Islam, law and religion are now different. Both emanate from the words of Allah. So if Allah has commanded a particular thing to be done in a particular manner, that applies to law also. There is no difference between Islamic personal law and Islam per se, Islam as a religion. So he said, no, I can't go against Islam. You are secular, all that is fine, but so I am a Supreme Court judge, still I can't go against Islam. So the matter came to be referred to a constitution bench. And then the Chief Justice was Y.V. Chandrachud, present Chief Justice father, Yashwant Chandrachud. Now Justice Chandrachud and 5 D.A. Desai was a communist judge in the Supreme Court. Then we had Chinnappa Reddy, I guess, and one more judge. So 5-judge constitution bench heard this matter. Then they quoted from Holy Quran to say that you have to pay compensation, but they did not fix the compensation. They allowed Shabano to go back to trial court to file an application under section 127 and enhance the compensation, but they granted 10,000 rupees as legal cost to her. So she got 10,000 rupees. Now halt here, I'll tell you who fought the case on behalf of Shabano is also equally interesting. His name was Daniel Latifi. Now has anyone heard of Daniel Latifi? Now, Daniel Latifi was a senior advocate in Supreme Court. Now he is projected as the champion of Muslim women rights in India. Now Daniel Latifi is an interesting character. He was a student in Oxford when Jinnah came for some work in London, in England. He met him and he said, that was during 1930s. Then he asked Jinnah, do you know why you are badly defeated? In every election, Muslim League is, getting a crushing defeat. You know why? He said, no. It is because you don't think like a communist. Muslim League should start thinking like a communist to win elections. You see, I'll show you the impact. Induct me in Muslim League. I will show you how to win elections. He was inducted. He drafted the Muslim League's manifesto in 1942 elections, 1946 elections. 1946 elections, 90% of the Muslims all over India voted for Muslim League candidates, including those in Bangalore. There were Muslim seats, Muslim electorates, so all of them voted. Daniel Latifi was a communist. He supported Muslim League by saying Hindus are exploiters. The Lalas and Baniyas of Lahore have exploited the Muslim masses. So the Muslim League is nothing but communist party in the renewed phase. So therefore we should support the Muslim League. And partition is nothing but a communist revival. And that is when our Shabana Azmi's father, Kaifi Azmi, wrote Agli Eid Pakistan Mein. It was a famous poem written by him. And Daniel Latifi is the lawyer who advised Jinnah in carving out Pakistan. He remained in India. He said, Pakistan is there, but you see, the other provinces also have to be annexed. So I have to remain here. So he remained here under the garb of a progressive advocate, senior advocate, and fought women's cases. And rest of the time he was busy hatching conspiracies and creating simis. So he is the one who fought, because nobody will get a doubt. If you see a progressive Muslim, you never get a doubt. You feel so you get a fan following. Oh, he's a women's right activist. He is such a progressive person, very interesting person. So many had a huge fan following, but rest of the time he was engaged in the same activities that he was engaged pre-independence. So next slide, please. So Shabanu, I have told you that this is what, Now see the Allama Iqbal's quote that Supreme Court has given in the Shabanu's case. They say the question which is likely to confront Muslim countries in the near future is whether the law of Islam is capable of evolution, a question which will require a great intellectual effort and is sure to be answered in the affirmative. So this is a very interesting statement quoted by the judges, 5 judges in Shabanu case. Whether Islam is amenable to change is the question that will confront all intellectuals in the future phase, but that will be answered in affirmative. That means it is amenable to change. That is what Allama Iqbal said. Whether the prophecy has come true or not, in Article 44 of the Constitution is very clear. The government should implement uniform civil code, but for political reasons you are not implementing it. It is rather political than legal. So we all know it has to be implemented, it should be implemented. They were actually worried and pained by the plight of Shabanu, and that is what made them write this paragraph. Now you see the words political courage. I think Daniel Latifi is the lawyer who said, sir, this is all correct, but how many political parties have political courage? So that is what they quote from there, that one of the lawyers whispered that they have no political courage, but slowly we have to go towards this age. So this Shabanu case is of 1985. Next slide, please. So what happened thereafter? Rajiv Gandhi was the Prime Minister and he commanded about 420 seats in Lok Sabha. Today, people envy Modi, 300 plus seats. Rajiv Gandhi has 426 seats in Lok Sabha. So he had a brutal majority. And that time, they passed a law called Muslim Women, see the name of the law, Muslim Women Protection of Rights on Divorce Act. Very interesting. It's a cruelty inflicted. When you want to inflict cruelty, you inflict in so insinuating manner. So what this law said, very interesting law, it is available on the website, you can Google it. The law says that Muslim woman is entitled to compensation only during iddat period. If she is menstruating, then 1 month, not menstruating, 3 months. So only for that period she is entitled to compensation. Otherwise, like a cattle, she should be driven away. So this is what irritated Arif Muhammad Khan today. He resigned as a Minister of State. He was part of Rajiv Gandhi government. Now see the courage of that man. With 425, brutal majority of Congress, nobody even imagined that Congress will ever lose power in India at that stage. And he is what, 1946 born. Just imagine 86, 40-year-old. And made a state minister in the Union Cabinet, resigned. This is the courage of the man. And Arif Muhammad Khan wrote articles also in the newspapers then, that how draconian this law is, the Muslim Protection of Rights of Protection of Women on Divorce Act. And subsequently he joined Janata Party, then he joined BSP, all that is history. But please mind you that this was the courageous man who registered protest. But even then, the shameless government then did not change the law. No women rights champions, no progressive elements, big bindi, feminists, nobody opposed because they were very happy that Muslim women were getting tortured. You see, this is a very interesting thing. I would stop here and tell you, why do the Muslim fundamentalists always support these draconian laws? That is because Islam can be revived and sanitized only by women. And if women rise up to the occasion, then the real revolution starts. You see, Iranian revolution, how women protested and became the vanguards of that revolution. They suspected that if Shabano, this law is opposed and the women rally behind this law, then there will be an Iranian kind of a revolution in India also. Was harassed by a man in her locality. He wanted her to marry. Usual acid attack case. He dropped 20 drops of acid in her eye. Right? Next slide, please. So, her name is Amina Bahrami, and the man who did this was Majid Mohvedi. Now, when this attack case happened, this lady, courageous lady, Amina, went to the Iranian court. Ayatollah Khomeini was the head. Islamic law was in vogue. She said, look, Islamic law is prevalent in Iran. What does Islamic law say? When you eye for an eye, right? Please apply the same thing. Drop 20 drops of acid in his eyes also. The whole government got shaken. Oh, it's a man. How can you drop acid in man's eyes? Women is all right. Women bound to suffer. Man, how? They never allowed that. Dodged. The matter came up to court several times. Dodged. Then finally, somebody wrote an article in some Saudi Arabian daily that Iran is becoming a weak nation, un-Islamic nation. So then they said, yes, we should have an Islamic law implemented, and that man also should suffer the same fate as this lady. Okay, uniform criminal law, right? But Iranian criminal law is different, but Islamic law should be implemented, and finally that man, same fate was met. But in the meantime, this lady was so courageous and so empathetic. She said, I don't want that man to face the same fate. I just wanted to expose you. That is why I did this. But I don't want that man to suffer. Whatever is your civil law, you implement. But still then, the same fate, I think I'm told that 20 drops of acids were poured into his eyes by Iran. Now see, Iran is an Islamic country. They respected the Islamic law. Correct? So those of us who are opposing the Uniform Civil Code are saying you should have a religion-specific law. Let us accept it is very logical and correct. Why should we not have a religion-specific criminal law also? Who asked? Now see, Iran walked the talk. Iran implemented. Now, India also should implement that. Now, people who support Uniform Civil Code should at times ask that if not for Uniform Civil Code, let us have ununiformed criminal laws. You see, now that brings us to the interesting question. You go to any civil court today, any person of any religion goes to civil court today with a property dispute, divorce, any law for that matter, for any legal remedy for that matter. What is the process followed? Normal process followed. You file a case. You file a petition or a plaint as the case may be. Then the plaint is checked by the registry. It goes to the next level. It comes up before the judge. Then notice is issued. And after that respondent or the defendants appear, then evidence, all this. How? If I'm a Muslim, same process. If you are a Hindu, same process. How? It is because we have something known as Civil Procedure Code, CPC. Civil Procedure Code is uniform to all, to Hindus, Muslims, Christians, Buddhists, Sikhs, everyone. If we can have a Civil Procedure Code, a uniform Civil Procedure Code, why can't we have a uniform civil code? Otherwise, there is a popular saying in Kannada, Kaji Nyaya. Kaji Nyaya means what? You see who is stronger of the two, then you make a, some kind of a equitable distribution of justice and make them rafa dafa, right? This is called Kaji Nyaya. Why not have a Kaji Nyaya to a Muslim? Why should he have a civil procedure code followed? If civil procedure code has to be uniform to all, then civil code also has to be uniform. Otherwise, let us have criminal laws also bifurcated, is what is the logical sequel. Those feminists, leftists, all those progressive people never think from a woman's perspective. If you put yourself in a woman's body and mind, you will realize how uniform civil code is the most important necessity of present times. Why? Because Muslims and Christians, any Abrahamic religions, do not have a right of adoption. You cannot adopt. The concept of adoption is alien to the scheme of Muslims and Christians. Now what, so there are about 12 million orphaned children today and only 4,000 get adopted. This has a direct relationship with polygamy. Why Muslims are tempted to marry twice, thrice, and why are they permitted today is because you can't adopt. If you don't have a child, you can't adopt a child. You have to marry another woman. One. Secondly, Muslim daughters get half of the share of their brothers. If suppose 100 rupees is father's inheritance, 50 rupees goes to the son. I mean, in Hindu law, 50-50. Right? Now, women have equal right to property. There it is half of your brother's share. So, any Muslim couple with no children can't adopt. He has to marry one more lady. Or if you have daughters, then your property cannot be shared by daughters. It goes to your relatives. Your daughters will have only half the share as your sons. Only daughters, then it goes to somebody else in the religion. So therefore, you are tempted to remarry. The polygamy in Islam has a direct correlation to the non-implementation of uniform civil code because they have no right to adopt. Now Supreme Court, I am told in 2005, Justice Sadasivam said Muslims have a right to adopt under JJ Act, Juvenile Justice Act. But that is again a very tedious process. Religion doesn't sanction it. If you are a devout Muslim, you don't adopt. Then what happens? Just imagine. Then adoption right is, a mother understands the love and, affection that she bestows on the child. Only if you think from a woman's perspective, you understand the plight of that woman. Just think of crores of Muslim women who cannot adopt, who have no children, who want to adopt but can't adopt. Recently one case was filed in Karnataka High Court also. That was dismissed, saying that you have no right of adoption because Islam doesn't recognize. This is, I think, even many progressive leftist Hindus also have asked this question, how can you adopt? You are not a Hindu. How can you adopt? Because only Hindus have a right of adoption. They give a very smiling response to that. Now anyway, because many communists also adopt. So how? You are not a Hindu then. So this interesting, we'll come to this interesting facet, then throw open to response. You see, you take any Hindu law today, it is not applicable to scheduled tribes. This is very interesting. In Jharkhand and Chhattisgarh, many interesting cases have come up in the High Court. Men have married twice, thrice. Bigamy is alleged and complaint is registered. He says, I am a scheduled tribe, no law is applicable to me. Very distressing. While Hindu society is thinking of a uniform civil code, it should also think of adopting the Hindu laws to all Hindus. Now, we have many scheduled tribes in Karnataka. All are Hindu, many are Hindus. Very few tribes are non-Hindus. They practice all the social customs and religious customs of Hindus, but they can marry twice. How? Because Hindu Marriage Act is not applicable. There was a very famous lawyer, I think everybody now, I don't have problem in even disclosing his name, though I am being videographed. Ram Jethmalani came to know that Hindu Marriage Act is going to be implemented on a particular date. So he married, he was already married. Just before 2 days before the Hindu Marriage Act was implemented, he married again. Because before Hindu Marriage Act, it was legal to marry twice or any number of times. So this is the fate of Hindus, women in scheduled tribes. And scheduled tribes have most vulnerable sections of the society, they are suffering this. So Hindus must concentrate on this as well. Now next issue is, this is I think often advanced by many people who oppose uniform civil code. What they say is, look, some of us may be chartered accountants here or financial professionals here, right? Hindu undivided family is a separate assessee unit, right, from the individual. HUF has a separate assessment from that of an individual. It is a separate legal entity or an assessable entity at least. So you get income tax benefit. Hindus have that benefit. Suppose uniform civil code comes, you lose this HUF benefit. Because Hindu undivided family is a very Hindu phenomenon. In Muslims, you don't have an undivided family concept. Now we should understand what is this Hindu undivided family concept. Many people think that if I am living separately from my parents, okay, if I have a different house, I stay 200 kilometers away, 2000 kilometers away from my parents, I don't belong to that HUF. I am the karta of my HUF because I am in a nuclear family. No. Unless there is a written partition effected in the family, Hindu undivided family continues. This is unique to Hindus. Okay. By separately, living separately, or somebody living, having two kitchens in a house, no HUF is dissolved. HUF continues. This is very unique to Hindus. But in Muslims, do you have this concept? No. In Christians, you have this concept? No. In HUF, Hindu undivided family, father, karta, is only a trustee. He doesn't own the property. He is like a trustee. He has a fiduciary relationship with the, he does it like a trustee. He has no personal interest. He cannot sell the property unless it is used for the benefit of the HUF. Right? Such concepts are alien to Abrahamic religions. Then, suppose you bring uniform civil code, then where is this concept? It goes. So this also needs to be studied and some response has to be shaped. Then within Hindus also you have Mitakshara, then you have Dayabhaga, Aliya Santana, many laws within that. So whether it disturbs the diversity of Hindus is one question that many people ask. It may not, but still, Bengal still follows Dayabhaga Hindu law, where the inheritance patterns and some other aspects are totally different from Mitakshara school of law, which is followed here in rest of India. So uniform civil code was subject matter of the 25th Law Commission report, which was headed by Justice B.S. Chauhan, the one previous to that. Now it is headed by Justice Avasthi, this Law Commission. The previous Law Commission was headed by Justice B.S. Chauhan, and he said there is no urgent need to implement the Uniform Civil Code because there needs to be deliberation. This deliberation is this. Even today, this Law Commission has issued a notice asking every stakeholder to write to them about their views. So if at all we have to think of implementation, we have to think on these aspects as well and thoroughly think before implementation. But we all know what HUF is. I told you, the law says that HUF property, if you want to prove that it is non-HUF property and my property, it is not in the family hodgepodge, but if you want to prove that it is your individual property, the presumption goes back to 3 generations. You see, my father, my father's father, father's father, leaving me, the 3 generations. Okay, so that is the HUF, actuals in the actual sense. That is the the joint family tree in the Hindu law. Okay, so it is that thick, that discrete. So this immediately after father's death, there is no presumption that the property is yours. Even if the children are staying outside, it is still presumed that it is HUF property unless you prove it to the contrary. If you prove that I never stayed with the burden of proof is on you. Okay, if you are alleging that it is your property. So HUF has been a major source of income tax planning, I won't say evasion, planning for Hindus, right? Now suppose the Uniform Civil Code comes, whether Hindus will be bereft of that benefit. Material benefit is one aspect. I am saying Hindu undivided family as a concept goes. Now Hindu undivided family is a religious concept also. Rather, apart from being a legal concept. No Abrahamic religions have a concept of family. It is all nuclear in their set of things. So this is one area that needs a deeper deliberation. Whether we can have a uniform civil code In about 80% of the matters, and rest of the matters we need not have. See, for instance, I'll give you another example, marriage. Saptapadi is an important custom, and Saptapadi is one of the proofs of conclusion of marriage. Now, Hindu Marriage Act says so. If you have a uniform marriage act, then this is one issue that needs deliberation. Another issue I'll tell you. Suppose a Hindu woman marries a Muslim. I had made a video also, maybe some of you might have seen that. I request Manthana also to circulate that once if you have. It was in Samvada channel, YouTube channel. So I argued that a Hindu woman marrying a Muslim without conversion is in a fasil marriage. Fasil marriage is an improper marriage. Okay, under Hindu Marriage Act, only Hindus can marry. Okay, if you are even a Muslim cannot marry a Hindu under the Hindu Marriage Act. Similarly, under Muslim marriage customs, Hindu cannot marry. That is why they convert, to Islam before marrying you, right? So what if somebody doesn't want to get married and somebody doesn't want to get converted, somebody doesn't want to get married under the Special Marriages Act. So what happens? That is a fasil marriage. That is a voidable marriage, improper marriage. No property share, and husband need not give any talaq. He is not married. What talaq? No marriage. So marriage, solemnization of marriage is evidenced in different ways in different personal laws, right? In church they maintain a register of married people. Birth register is maintained. But if you make a uniform civil code, then what? How is the issue? And in Abrahamic religions, I am telling you again, Abrahamic religions, the religion is not divorced from law, codification within that religion. See, the Islamic jurisprudence, there is something, a concept of crime against people, crime against God. Crime against God has highest punishment. Crime against individuals has lesser punishment. That is all codified. That is all in the scriptures. It's a scriptural dictate, right? Now, you make another law that violates that violates their religion. So those who are saying that, look, our marriage is our religious custom. It is integral to our religion. To them, we ask them, why are you accepting a criminal code then? Your Holy Quran has a particular punishment, for criminal punishment for a particular offense. You should accept that. If you can accept that, then accept the civil laws also, is one argument. But Hindus also have a problem. Suppose whether we lose our religious sanctity, whether our religious customs get compromised because of uniform civil code, because everything becomes secular. Okay, one of the arguments that Dr. Ambedkar said was, in the course of his debates in the Constituent Assembly, he said, why should you allow the religion to take so much place in your life? Let there be a secular commandment for all your secular affairs. But marriage is not a secular affair in Hindus. Marriage is not a secular affair. Marriage has a religious meaning. Vivaha has a particular meaning. So, a religious ceremony cannot be secularized. So, this needs some deliberation.